Who is responsible for Taiwan's defense?
Part 112.
Preface 2. A derivation of the international legal status of Taiwan.
Based on the delineation of categories of territory found in U.S. court decisions, and with reference to the historical situations of Cuba and the Ryukyu Islands,
and customary international precedent regarding the disposition of territory after war.
Fundamentally, we need to recognize that
all territory under the jurisdiction of a particular country is not necessarily domestic territory.
To aid in the discussion of this concept, illustrations from United States history will be given for reference.
Example 1.
One common situation which arises is when U.S. military troops have occupied some particular area. The United States military occupation of the northern and central Mexican states during the Mexican-American War is a good example of the category of foreign territory under the jurisdiction of the United States.
Example 2.
Even in situations after war where territory was ceded to the USA by treaty, and was added within the boundaries of USA national territory, such territory was still regarded as foreign to the states of the Union. Additionally, it was held that the U.S. Constitution did not apply in its entirety to these areas, whether during the period of United States military government, USMG, jurisdiction or later when the local civil government was organized. Examples are Puerto Rico, Guam, and the Philippines after the close of the Spanish-American War. In the early to mid-1900s, some scholars wrote articles examining the legal treatment of these territories, and concluded that they were foreign in a domestic sense.
Example 3.
A further peculiarity is where U.S. military troops liberated the territory. The original sovereign renounced its sovereignty in the peace treaty, but no recipient country was designated. In such situations, U.S. court decisions have found that United States military government, USMG, jurisdiction continues, and such an area is foreign territory under the dominion of the United States. Cuba, as a result of the Spanish-American War, and before its independence, is a very prominent example.
Example 3, continued.
As stated above, after the coming into force of the Spanish-American Peace Treaty, although not ceded to the USA, Cuba remained under USMG jurisdiction. Interestingly, during this period of time, and before the founding of the Republic of Cuba, the island was a non-sovereign entity. More specifically, it was neither part of the United States, nor was it independent in its own right. Such a description amounts to saying that Cuba had not yet reached a final political status.
Example 4.
Another example of the non-domestic treatment of territory is foreign territory leased by the USA. Guantanamo Bay, Cuba, is one well-known example which is often in the news.
Summary.
As an overview of the above four examples, it is quickly seen that all of these situations have arisen as a result of the conduct of war.
Accordingly, the recognition and understanding of these situations is typically beyond the capabilities of those civilian scholars who have no background in laws of war studies, which we may refer to in a somewhat broader fashion as the customary laws of warfare.
Laws of war studies.
This field of study includes the Hague and Geneva Conventions, the laws of occupation, as well as much other customary precedent which has been established over the last 200 years. It also includes the subject matter of military jurisdiction under the U.S. Constitution and the legal ramifications of the principle of conquest, academic areas in which most civilian scholars have essentially no knowledge.
In fact, references to the content of the above areas of scholarship have been made frequently in this series of films.
There is much confusion in the world today which arises from
the misconception that all territory under the jurisdiction of a particular country is domestic territory.
For discussion purposes, let us use the nomenclature of country C to designate one particular country.
The following problem arises. By regarding all territory under the jurisdiction of country C as domestic, it then becomes a simple mental leap to say that country C can obtain new territory merely by issuing a proclamation or holding a press conference, and then sending in its troops. When the military forces in the conquered territory surrender, the officials of country C can announce the annexation of the territory, and the war is over.
Rigorous distinctions are needed.
Those scholars and researchers who unwittingly assume that all territory under the jurisdiction of a particular country is domestic territory also fail to make a rigorous distinction between having sovereignty over a piece of territory versus merely having jurisdiction over that territory.
Research into the customary laws of warfare and a close examination of examples 1, 2, and 3, above, quickly show that a. Not all territory under the jurisdiction of a particular country is domestic territory, b. Having jurisdiction over territory and having sovereignty over territory are two distinct concepts.
Territorial cession in the modern world.
In the post-Napoleonic world, territorial cession is accomplished by treaty, and the world history of the last, nearly 200 years provides many examples. In the 1800s, the difference between military occupation and annexation became firmly established in customary law, and was later formally codified in the Hague Conventions of 1907.
Territory is considered occupied when it is actually placed under the authority of the hostile army.
The form of administration by which an occupying power exercises government authority over occupied territory is called military government.
In the Spanish-American War examples given above, Spanish sovereignty continued until renounced in the peace treaty.
United States Military Government, USMG.
United States military government, USMG, jurisdiction over these four territories began with the surrender of Spanish troops in each area, and continued, beyond the time when the peace treaty came into force, for many years.
USMG jurisdiction was finally supplanted by the establishment of civil government for each territory.
This is the established precedent for dealing with conquered territory.